So welcome everybody to Ask a Pro number 6. My name is Linda Plano and I have the best job in the world. I get to work with smart, creative, and passionate people just like you and help you make your dreams come true. That's because I am a pitch coach, and over the last decade I've had the privilege of coaching nearly 600 mostly high-tech entrepreneurs, and they have gone on to raise well over $250 million. But you know, there are so many other things you need to know how to do in addition to pitching. So this Ask a Pro webinar series is designed to bring other experienced professionals to you so that you can get their insights firsthand and get your questions answered in real time. I'm going to turn things over to today's guest, Jerry O'Connor, in a moment, but first let me do just a little housekeeping. And first, of course, is as always to say thanks to Katya and Amy at the MIT Enterprise Forum of Cambridge. And the Mentor Smart program, I'm co-chair of that with Craig Sanders and Barb Feiner. And we have just opened up started the 5th cohort of that with over 200 people going through it so far. If you are a member of that cohort right now, more email and good stuff coming to you shortly. We have one last webinar for the year next Thursday. Jerry, I'm getting a lot of background noise. Okay, so one more webinar this year on next Thursday at noon. Website interface design is actually a little bit out of date. It is actually digital design for startups. And the big question, if you don't think digital design is important to you, ask yourself the question of who cares what it actually looks like, whether that's your videos, your presentations, or your websites. It's really everybody who invests in you, your users, your customers, your investors, and therefore you. So I encourage you to come and listen to it. It's a new firm that actually does a lot of work, not only with startups, but also with entrepreneurs in the developing world. So really cool organization, really beautiful work. Also, we'll be having a bunch of exciting new projects, new webinars coming. The post-webinar polls have shown me that angel funding, proposal writing, recruiting team members, maybe managing team members, negotiation strategies, and corporate law, and maybe even some bootstrapping information would be super useful. So I'm just going to take a moment here, and I'd like to put up a poll because this is just what I get from people who take the time to fill out the survey at the end. So I'm going to show a poll right now for a few seconds. And ask you to make a vote here as to which of these, if any, are interesting to you. So just to share with you for a moment, here's what the results are. Good news for you guys, angel funding is at the top of the list for me anyway. So stay tuned. Do take a look at the Ask a Pro playlist or the Ask a Pro sign up in order to get the latest information. Okay, so let's hide that and keep moving. Oh, also, yes, I do like to twist the arm of my guests to make sure that they give you some free time slots in order to have an extra benefit for attending these webinars. So please stick around till the end and I'll give you the rules that go along with that. But let's now get to what you really signed up for here. Now, Title III crowdfunding was finally approved by the SEC on October 30th, as I understand it, which means that it's expanded beyond the project-oriented funding on portals like Kickstarter and can now be used for equity-based funding, which is incredibly exciting and also kind of scary because no one really knows how it's going to work out for the investors or the entrepreneurs. I mean, my advice as a pitch coach has always been to have fewer larger investors, as it's hard enough to keep a few of them informed and happy. But by definition, crowdfunding means you'll have a lot of people, many of whom have pretty little experience in high-risk investment. So when the final rulings came through at the end of October, I really wanted to have someone knowledgeable and approachable on Ask a Pro as soon as possible. We're very fortunate to have Jerry O'Connor with us today to help us understand what it all means. Now, Jerry has been representing technology entrepreneurs for 2 decades, and he and I have actually worked together for fully half that time, which is kind of depressing in the sense that I didn't realize I was getting so old. But both of us, we've worked together both as volunteers for the MIT Enterprise Enterprise Forum and professionally. While I was CEO of a software startup, he was my corporate attorney, for instance. I've seen him transition from one large law firm through to smaller ones, and I am just so pleased for him that he finally decided to start his own firm where he can be as responsive to entrepreneurs as he wants to be, as well as doing his other work, because he does provide services not only to startups, but general corporate representation and acts as M&A counsel in software, financial services, manufacturing, robotics, energy, and more. He's my go-to guy here on so many of these things. So please join me in welcoming Jerry O'Connor.
Thank you, Linda.
You are very welcome. Here it comes. Oh, and people, please do feel free to ask questions anywhere through here. You can either put your hand up, I'll be keeping an eye on that, or if you don't want to talk specifically, you can use the questions box. So let me just check right now. Everybody, please raise your hand if you know where the questions box is, please, so I can be sure that everybody knows where the toolbar is and so on. Okay, a couple people. Okay, if you're having trouble finding it, look in the top right corner of your screen. There should be a red and white arrow. If you click on that, it will open up the toolbar, and you can just kind of scan down and find the questions things. Okay, looks like we have most people know what I'm talking about. So I'm not going to, just going to say, Jerry, let's get going. I'll keep my eyes open for the questions. And all right, let's do it. We have your screen online, so go ahead and put it in slideshow mode and we're all set.
Great. Now, thank you, Linda. And let me start by re-emphasizing a couple of points that Linda made. Number one, please do raise your hand or otherwise indicate to Linda that you have a question at any time. I much prefer taking questions as we roll through this as opposed to saving them up to the end, because you'll be more likely to ask a question, I find. It's more interesting for me, so I don't have to listen to myself talk for this whole time, and we can sort of make the questions stand out in the right context, I think. So please do ask questions as we proceed. And before we get into the substantive slides, there are opportunities, pitfalls, and of course regulations related to crowdfunding. But I also want to touch upon another point that Linda made, and that I think it's generally good advice for any startup to limit your number of shareholders if you can, and get more money from fewer investors. That, of course, is the opposite of crowdfunding. So let me counter that immediately by also observing that even one investor can be really bad if it's the wrong investor. And so a lot of what you're going to be doing if you're contemplating crowdfunding is thinking about what the world's going to look like if you've got, your startup, you've got your team, you need positions to fill, you're trying to build your product, and you're trying to get customers, and you're trying to manage all that stuff. And now you have a whole new community of stakeholders to manage as well. So a soft skill that you're going to need, and something that's not written into the regulations, but you're well advised to take an inventory of the skill set among your team, is do you have those communication skills? Do you have social media skills? Are you going to be able to keep maybe several hundred people satisfied with the extent and quality of your communications to them? So if you have misgivings about that, then that's sort of a yellow flag for crowdfunding. But if you're the type of entrepreneur that can handle that and you've got the tools to do it, then certainly let's examine this together. So without further ado, we'll talk about what the crowdfunding laws are, why we need them. We're going to focus on really the new SEC rules that have been coming in to place throughout this year, including most notably the Title III crowdfunding regulation that was promulgated on October 30th. We're also going to talk about something that I'm very interested in, which is the corollary in Massachusetts and a number of other states for intra-state crowdfunding, which I think is an exciting opportunity for the right kind of company and entrepreneur. We'll talk a little bit about the practical implications of all these new rules, who can use this, what you can use it for, what kind of companies it's good for, and what are some of the risks and pitfalls to worry about. And then we'll open it up for questions and answers at the end. But as I said, please do not hesitate to raise your hand or indicate to Linda at any time during the presentation should you have a question. So first, the nuts and bolts here. And I'm not going to get too deep in the weeds on regulatory citations and that sort of thing, but I do think we should have a solid grounding in why we're talking about this from a regulatory point of view. So if you've got a company, and as most people do, you're going to need money to fund your company and execute your business plan. You have to go raise capital. Since 1933, everybody that wants to sell a share of stock or a membership interest in their limited liability company or some other security has to do one of two things. They have to register that sale with the Securities and Exchange Commission on the proper form, or as 99.5% of all securities transactions every year in this country do, they have to find an exemption from that registration requirement. Most of the exemptions that this group will avail itself of, and really most of the exemptions available under the Securities Act and the accompanying regulations, are so-called private placement exemptions. Now, through the years, and remember, we're talking about a law that was written in 1933 and really hasn't changed that much in the intervening however many years. And in 1933, we barely had means of mass communication as we recognize them today. There certainly was not the ability to load up a document in a portal someplace and send it around the world instantly as we can do now. And so this idea that you have a private placement which does not include a general solicitation is a concept that we've been really struggling with since the 90s and the advent of the internet. And it's almost to the, I'm going to editorialize a little bit here, it's almost to the point where the regulators have to go out of their way to define what constitutes a general solicitation now, because there's almost no way you can produce a document and not have it instantly available to anyone in the world, no matter what precautions you take. All somebody has to do is make a PDF of the hard copy you give them, load it up on a website, and presto, pretty much anybody in the world can get it. So we'll see as we go through these rules and the programs that have been set up to effect crowdfunding, we'll see how this idea of general solicitation or no general solicitation still plays out, and the tension it creates from the perspective of the regulators on the one hand and the startup entrepreneurs on the other hand. So if that wasn't complicated and depressing enough, every state has its own set of securities laws and regulations with which you must also comply. Unless, again, like 99% of the offerings that are done every year, you find some way to get a federal preemption of state law. And if the federal exemption you have is a good one, it will do two things. It will exempt your sale of a security from the federal law and will also preempt the ability of the state administrators to regulate or prohibit that offering. And I think we just covered everything on this slide, so I'll move right along. Now, before the Jobs Act of 2012, the primary means to get exempt offerings done was Reg D. This is your classic angel investment, friends and family round, or most particularly venture capital investment. Every venture capital investment is done under Reg D. Most angel rounds are done under Reg D, even some friends and family. So what is a Reg D offering? You can't make a general solicitation. There's that phrase again. That means you have to go seek investors with whom you've got some existing relationship. Very difficult if you're coming out of a lab or if you're coming out of a garage and you don't happen to know a lot of accredited investors. You've got to go meet them, get introduced to them, make your pitch, and then you can sell only to accredited investors. You can sell up to 35 non-accredited investors, but nobody ever does that under Reg D, because in order to sell to any one of those 35 non-accredited investors, you've got to basically give them a prospectus that's equivalent to what you would be doing if you're going public. Impractical, so not used. You don't have to give all that information to your accredited investors, but you can't do what we now know as crowdfunding under Reg D. By the way, an accredited investor is somebody who's got $1 million of net worth, not including the equity in his or her primary residence, or who has, for the past 2 years, had at least $200,000 of income or $300,000 of income together with his or her spouse and has a reasonable expectation of achieving the same level of income in the current year. If you meet one of those two criteria, then you're an accredited investor and you can invest in Reg D deals. That continues to be meaningful, as we'll see in a few slides from now. So under that regime, and given some of the other much more seldom used exemptions from registration, companies have some well-known issues. They're very limited as to whom they can offer securities. They can only go to accredited investors, angel investors, venture capitalists, and the like. And it's very difficult to raise that early money that companies need to get over the so-called valley of death. And I think after practicing as long as I have, that there's certainly more than one valley of death. There's a series of valleys, and they can all be fatal. And the ability to match up an investment profile with what an angel investor or a venture capitalist is looking for with no money is a daunting challenge indeed. And the idea of going out to the crowd and getting some fans of your product and some people that are interested in what you're working on to fund you with smaller amounts is very enticing. And as we said a couple of slides ago, if you are doing a Reg D deal and only selling to accredited investors, you will have most likely an exemption under state law. If you, for any reason, are unable to achieve the federal preemption, then you're going to have to register your offering or find a corresponding exemption under the state law. The most common way that people find themselves in this situation having to forego a federal preemptive Reg D offering and having to register their offering in a state is if they've got somebody whose money they need and who they need in the deal but is not an accredited investor. And it happens, and I counsel people to try to stay away from that situation if they can. But look, at the end of the day, it's an investment is an investment. If you've got somebody who knows what they're talking about, can withstand the risk, wants to invest in your company, but doesn't meet that criteria for one reason or another, you might be tempted to go along and take that investment anyway, in which case you have a much more complicated deal to close. So this was, for a long time, seen as very problematic, and finally, in 2012, what I would call a monumental piece of legislation was passed and signed into law, the Jobs Act. And I'm categorizing the reforms, the major reforms of the Jobs Act into two main categories. You might be inclined to break them out into three categories. The first category was one that got off the ground and it has been up and running for a couple of years now. That's Title II crowdfunding. The second one was all the stuff on the right-hand side of your slide here, equity crowdfunding, or so-called Title III crowdfunding, which was a much more longer gestation period, and the final rules for which were just promulgated last month, now 2 months ago. And we also see on the right side of the page Title IV crowdfunding under Regulation A, which I'm going to spend a little time on. I am not personally as excited about Reg A as some people, so that's my own bias. Happy to talk about it, happy to answer any questions about it, but for the reasons I'll get to, I don't believe that it's likely to be as important an element as Title II and Title III crowdfunding will be. And meanwhile, when we're talking about Title II crowdfunding, Title III crowdfunding, Title IV crowdfunding, and in the end of this presentation, intra-state crowdfunding, all of those are equity crowdfunding. They're means by which an entrepreneur can raise equity for his or her startup. So we're going to distinguish all of these from what we came to know as prototype or project crowdfunding, Kickstarter, GoFundMe, and those other sort of mission-driven or project-driven or outcome-driven crowdfunding efforts. So you can still go out on Kickstarter and say, I'm making a movie. If I get $100,000, that's the budget I'm going to need. Please send me, donations of, $100, and you'll get a ticket to the movie. Send me a donation of $500, and you'll get a credit at the end, et cetera, et cetera. That's not selling a security. That's selling something else, or it's really asking for a donation. So nothing in this presentation has anything to do with Kickstarter or GoFundMe. We're talking about selling people shares of stock in your company. So I want to make that I want to make that distinction in case that's still unclear to anybody. Anyway, Title II crowdfunding was subject to rulemaking by the SEC. Fortunately, the SEC made those rules rather quickly, probably because Title II crowdfunding was still going to be limited to accredited investors. The main benefit of Title II crowdfunding, and the main way you see it in use now, is that under the new rule 506C, the prohibition on general solicitation or advertising of the deal is now gone. You no longer need to approach only investors with whom you've got a pre-existing substantial relationship. Now you can advertise your offering, provided two things. Provided, number one, you only sell the shares to accredited investors, and provided, number two, that you've taken reasonable steps to verify their status as accredited investors. Now, a lot has been made out of this whole verification thing. In the old days, pre-Jobs Act, you were still supposed to be only selling to accredited investors. So let's keep that in mind. And this idea that somebody has to verify their accredited investor status as opposed to just whatever the rule was before, I always thought that it was the same thing, has been I think overinterpreted, and people have been overly worried about it. In my experience, all it really takes is a letter from your accountant saying, I'm this person's accountant, I do their taxes, they're accredited, signed the accountant. And that has been sufficient to achieve verification of accredited investor status in Title II crowdfunding. There are a lot of sites out there doing Title II crowdfunding. You might be familiar with some of them. Microventures is one. WeFunder is another one. Fundrise is specializing in real estate crowdfunding, and they're doing Title II crowdfunding. It's up and running. It's been vastly popular. I've got clients do these crowdfunded deals with WeFunder, and it's working. And the tires have been kicked, and there's a pretty good program up there and several crowdfunding platforms to choose from. So now moving along to Title III crowdfunding, um, there's going to be, we'll go through this in more detail, there's more hoops to jump through, there's more difficulties, and there are more limitations on both the types of investors you can go after, but more importantly, the number of dollars those investors can invest. So let's see. We've got the 33 Act. You've got to register your securities or find an exemption. And we've got the Jobs Act that now is really aggressively going after this general solicitation prohibition and putting out three distinct paths toward the market that was not accessible before 2012.
Wait,
The first of which,
Jerry, if I can
yeah,
interrupt for just a second, Catherine would like to know who it is that's doing that Title II crowdfunding for real estate.
oh, there's a bunch of people. One is Fundrise, and I'm happy to, I can shoot you an email with some links to other people that are doing it. I'm also, and I'd be happy to talk to you if you have a question about crowdfunding for real estate in particular, because there's a lot going on here, and I'm aware of a couple of initiatives right here in Massachusetts to get a similar program up. And so anybody on this call that has an interest in real estate crowdfunding, that is also an interest of mine, and as I said, I'm working with a few people on that. So let's make sure to touch base.
Okay, great. I'm just asking her if she wants to get unmuted later on if we don't run out of time. So don't let me
Okay.
hold you up any further.
Okay. So as I said, I'm going to talk about Reg A little bit, and I'll be totally honest. I only added this slide after Linda got a question about it. I wasn't really going to talk about it. I think I'd be surprised if there was one Reg A deal done every year. That would surprise me, because I think the number is zero. I've done almost every kind of securities offering there could possibly be, reverse mergers, pipe deals, you name it. I have never done a Reg A deal, ever. And I don't think I ever will. It's really hard to do for the reason in the bottom of the middle column. Um, you've got to register with the feds, and you've got to register in every state. So now, what did they do to make it better? Well, they did a few things to make it better. It used to be the case that you could only raise $5 million in a Reg A deal. Now you can raise 20 million or 50 million, depending on which tier you want to be in. Um, and if you want to be in tier one, that's a pretty good tier to be in. You can raise up to 20 million. You can sell to non-accredited investors. They can invest however much they want to invest. You don't need an audit. However, there you are in the bottom middle box. You still got to register with the feds and register in each state and coordinate registration. So I don't know if people have an opportunity to raise 10 million bucks, they might do it. This is sort of color me. I'll believe it when I see it. It's just Reg A has proven to be so clunky and so hard to use, and the opportunity to develop a secondary market has eluded so many people who have thought about using it that it just hasn't been a robust neighborhood for capital raising.
It's such a significant amount of money, though. I was talking with some biotech, actually pharma people with small molecule drugs yesterday, and I was
Yep.
wondering, what has anything changed in terms of life sciences, healthcare related stuff? Is that viable for any of this crowdfunding, or is particular for a
Yeah.
tier one?
That's a good example. If you can find the money, absolutely. And let's look at tier two. You can raise $50 million in a Reg A deal. Now you're starting to talk about the kind of money that these companies need. And by the way, I'm going to editorialize a little bit more. When I started practicing law in the Bronze Age, um, this is before the National Securities Markets Improvement Act or NISMIA, but it was also before Sarbanes-Oxley, and it was not at all uncommon for a small company to go out on the Nasdaq small cap market and raise 10 million bucks in a public offering and spend maybe $100,000 to $150,000 on legal fees, accounting fees, and registration fees, and all that stuff. After the Sarbanes-Oxley Act was passed, those days were relegated to the dustbin of history. You can't do a standard IPO on an S1 for less than $1 million to $1.5 million in legal and accounting fees. It's just impossible. And so you're not going to do that to raise 10 million bucks. However, if you can do a tier one or tier two offering and raise 20, $25 million and keep your costs limited to some reasonable six-figure amount, now that part of the public capital markets might open up again. So that's my hope for Reg A. If people and if the law firms and the accounting firms can sort of gear down their operations so they can get these deals done um, on a reasonable basis, Reg A might actually, and the investment bankers, get on board and can help source the deals and place them, like the retail investment bankers that used to exist before Sarbanes-Oxley. This might turn into something, but we need that whole infrastructure to come back. We need all the small, non-Big Four accounting firms to be registered with PCAOB. We need the mid-tier law firms and the good small law firms to be able to do these deals, and we need the retail and smaller investment bankers to help get the deals done as well. All that stuff went away after Sarbanes-Oxley, and it has to come back, in my opinion, for Reg A Plus to be a meaningful avenue to capital raising. But it's there. The regulations are there, and so I don't want to, downplay it too much. So here you see the Reg A requirements. You can raise up to 20 million or 50 million, and if anybody wants to give that a shot, have at it. The only Reg A deal I've seen done this year since the rule went into effect in March has been one where it's a real estate company, actually, a real estate play. They raised $500,000, and their legal and accounting fees were about $500,000. So I don't know. that
Well,
that's
two things. First of
Hey,
all, we really love to have you editorialize on that. That's half the reason I have you here. And the second, the aspect of the question I was mostly curious about is I understood that initially you couldn't do the project-based crowdfunding for developing a drug or a specific kind of a medical device. Is that just an unfounded rumor, or is
like a
there
kick,
some restriction?
like Kickstart my drug discovery company.
Right. Well, not the equity aspect of it, but let's say,
No, no, right. Like a regular Kickstarter. Instead of making a movie, I'm going to make a drug.
yeah.
Yeah, I'm not aware of any
Huh.
reason you couldn't do that. Um it's not I don't think it's commonly done. I certainly have not seen my clients do it. I've seen clients of mine kickstart kickstart their album or their recording project or their tour.
Right,
That's in a
right.
different area of my practice. But yeah, I don't see it. It's a donation, so people can donate to whatever they want. And
Oh,
again, you're not
okay.
selling securities. Um, so I may be looking at it through my tunnel vision as a securities lawyer, but it's fine if people want to donate to
Great.
any legal activity you've got going on.
Okay, thanks.
Hmm. So regulation crowdfunding, the long-awaited regulation crowdfunding, finally came into being on October 30th, only about 3.5 years late. The SEC was ordered by Congress to pass these laws, I think 90 days or 180 days, or 270 days, sorry,
Yeah.
after the passage of the Jobs Act, and they were only about 3 years late. But that's okay because they're so flexible and easygoing when my clients are late with their 10Qs that it's only fair that they should have 3 extra years. Anyway, they finally got the job done, and they did an okay job. Um, they did an okay job. We'll take a look at the details of what they did. Um, so a lot of the requirements and limitations of regulation crowdfunding or regulation CF were imposed by the Jobs Act itself, and so the SEC did not have a lot of flexibility. They had some flexibility in some ways, and they took that flexibility in some examples. They didn't in other examples. So let's just go through this. What can an issuer do under a Title III crowdfunding deal? Number one, you can raise $1 million. Now, we were just talking about raising $50 million under Reg A, so now this seems paltry, but come on. For the first deal out of the gate by a startup, my startup clients would love to raise $1 million in a 12-month period. So this is nothing to sneeze at. Um, you have to use a broker-dealer to do your offering, or you can use this new creature, and we're going to get into this, called a crowdfunding portal, which does not have to be a registered broker-dealer. So that's something of a new of a new thing. That the SEC here and the Jobs Act is treading into new water here because now you have a deal participant, a deal intermediary that doesn't have to be a broker-dealer, and that's the SEC gets pretty uncomfortable anytime they see intermediaries in stock deals that are not registered somehow. And that leads to a lot of what we're going to see in a couple minutes as some of the restrictions on these crowdfunding portals. So I want you to bear in mind that it's new and different and scary to a regulator to have some sort of intermediary like a crowdfunding portal that doesn't have a Series 7 license or a Series 65 license from the FINRA. So that's what the issuer can do. It can raise $1 million through a dealer or a portal. What can an investor do? Well, an investor can invest the greater of $2,000 or 5% of your annual income. That's if you have income or net worth of less than 100. Or you can invest the greater of 10%. You can invest 10% of the lesser of your annual income or net worth up to a limit of 100,000. If both of your annual income and net worth are more than 100,000. So let's take your typical accredited investor. Under Regulation CF, I've basically got $100,000 a year I can invest as long as that's um, not more than 10% of either my net worth or my annual income. So if my annual income, if I'm an accredited investor and my annual income is only 200,000, so I'm barely an accredited investor, that $100,000 goes down to $20,000. That's how much I can invest in crowdfunding deals. I can still invest my whole income if I feel like it in a Reg D deal. So this doesn't limit accredited investors to other transactions, but it limits the extent to which they can participate in Regulation CF deals to this limitation. And I would imagine that what you're going to see is particularly in the ranks of angel investor type accredited investors. These are the people who maybe they don't have a whole lot of net worth, but they've got income of $400,000, $350,000, so they dabble in startups and things like that. You're going to see the biggest limitation being the 10% of the annual income. So so we've got funding portals defined under this under the new rules, and we're going to look at what they are. So first of all, if you're going to sell a security for somebody else, the general rule is you have to be a broker-dealer. It's like the requirement under the 33 Act that you have to register your share. in that people try to get out of that requirement, but it's much, much stricter and much, much tougher to find an exemption from that requirement than it is to find an exemption from the registration requirement of the 33 Act. So finally we have one in this definition of a funding portal. They made a couple of definitional changes to the Exchange Act and to the Securities Act to say, okay, if you're a funding portal, as we've defined it, you don't have to register as a broker to help people raise money on your website. So funding portals have things that they have to do, they have things that they can't do, and they have things that they can do if they want to. So the first things we're going to look at are the things that a funding portal has to do. First of all, it has to register with the SEC, and I think it's a Form FP, um, as a funding portal. Next thing they have to do is obtain membership in FINRA or any national securities association. You know, the law says you have to register with a national securities association. There's only one, it's FINRA, so that's who you have to register with. Um, don't have to pass a test to be a broker under what they call the Series 7 test, but you have to be a member of FINRA. You have to do some gatekeeping. If you're going to be a funding portal, you have to ensure that all the investors coming onto your site to buy shares have to positively affirm stuff about their understanding of the risks, their ability to bear the loss, and they can demonstrate their understanding of the illiquidity of the stock they're going to hold. You're going to do background and regulatory checks on all of your major stakeholders, directors, officers, and main stockholders. And there might be, the SEC says, other requirements coming down the road in the future, and if we prescribe more requirements, you have to meet those too.
So are the SEC and FINRA taking pretty close oversight of all of these funding portals that are popping up everywhere, or is that they're just going to do spot
No,
checks, or do you have any insight on that?
no. The answer is no. I don't have any insight. And the second and more long-winded answer is the funding portals we're seeing now, microventures, WeFunder, et cetera. Remember, those are Title II funding portals, subject to much, much lower degree of oversight and regulation. Here we're talking about Regulation CF Title III crowdfunding portals. And these, number one, are going to be, I expect them to be more closely scrutinized, but also the first day on which you can apply to be a funding portal hasn't happened yet. It's happening in January. And the rule we're talking about now doesn't even go into effect until either March or May, I forget which. So we haven't even had an application filed yet to be a Regulation CF crowdfunding portal under Title III.
But it's got to be pretty safe to assume that that these ones that are Title II already are going to be, at least some of them are going to be pretty interested in being Title III, no? Or is it going to be just too much overhead and it'll take a whole new crop of startups?
That is a very interesting question. On the one hand, you've got to think that if I'm WeFunder, I've got all this back office stuff done already. I can track investments. I can do tax reporting. I'm set up in all 50 states. Sure, that's why not? Why wouldn't I file an application to be a Title III crowdfunding portal um, and add that to what I'm offering? So it's going to be a little bit of a land rush, I think, and whether one of those guys steps in and becomes the predominant uh, Title III crowdfunding portal, or whether a bunch of new people come in, or whether it breaks down into renewable energy crowdfunding and real estate crowdfunding, it remains to be seen. I don't really have a good crystal ball on that one. I expect WeFunder to be a Title III crowdfunding portal, but I don't know. Nobody nobody has told me yet.
I'd be pretty stunned if they did. It'd be interesting to see whether it'll be sort of a first mover or a fast follower advantage that really plays out. But I don't know if you're going to get to this later, but do you have any cautions or suggestions on how to pick a site once they are available?
You know, not really. Although I would say, if I was counseling a client and WeFunder announced in January, guess what? We applied to be a Title III crowdfunding portal. Um, they're a known quantity. I've had clients close deals on WeFunder. No problem. They execute, and like I said, they've got the infrastructure and the back office systems built. And then if somebody else popped up and said, "No, I'm Joe's crowdfunding, and I'm a crowdfunding site too," you know, it's just like anything else. How much is it going to cost? What am I going to get? Are you a known quantity? I'd probably kind of lean toward WeFunder just because I don't want to make this into a commercial for them.
No. Yeah.
Other people might have had a bad experience, but my clients have had a good experience, so I'm favorably impressed
Well, and
with
they've
that.
been
Other
kind of
than that,
sorry, they've
yep.
been kind of instrumental in helping to get the jobs regulations passed in the first place, and I don't know what how much impact they've had in this latest thing as well, right? I mean, they've been really intensely involved, so I would expect them to be kind of up
Sure.
on
Well,
the latest.
I'm expecting them to, and I'm expecting them to be a formidable competitor in the market. But who knows?
Who knows?
There's
Right.
there's there's a lot of ways of looking at Title III that people don't like, and and we funders, I forget who the lawyers are, Cooley or one of those big Silicon Valley firms, and they might be drinking from the same fountain as a lot of the lawyers have who don't like Title III crowdfunding. So it remains to be seen. It's really an open question. So let me
Sure.
push along here. So here's the things that a crowdfunding portal can't do. Um, and this is where it gets a little bit funky. They can't offer investment advice or recommendations. Okay. They can't solicit purchases or sales or offers. All right. They can't pay deal-based compensation to their employees. Okay. Now that's the difference between a crowdfunding portal and a broker, because a broker can go get deal-based compensation all the time. They can't hold funds for investors. That's fine. Nobody wants to hold investor funds. And the SEC might ban other stuff later on. So this harkens back to the idea of, okay, we'll let you be a crowdfunding portal, but all the stuff, offering investment advice, holding client funds, paying deal-based compensation. If you ever looked at a Series 7 test, half the questions are about what you do with client funds, which is ironic because most of the broker-dealer issues that I come across in a startup securities law practice, no broker's ever holding. That's the deal finder that's getting your deal put together. That's the last guy anybody wants to see holding funds. I mean, we don't need the SEC to tell us that. So it's a little ironic, but these restrictions, these grow out of the idea that, hey, brokers are trusted individuals. Brokers, really manage the deal. Brokers hold the funds. Brokers solicit everybody. In real life, people who get early stage deals done don't do any of that stuff. So some of these restrictions, like holding funds, are not that important. But then when you get to deal-based compensation, that's always open to some interpretation. So that's complexity and pitfall number one that we've seen. So what can funding portals do? Well, they can charge commissions. I'm jumping to the third bullet because we just talked about deal-based compensation. So the portal can charge a commission to the issuer. Okay. They can charge upfront fees. It costs you X dollars to list on our portal. They can advertise. They can do like tombstone advertisements. You remember what those are. They can just say we're doing an offering. Here's our objective criteria, and there's some limitations on how they can advertise. And the final bullet here, this is a little glimpse into the regulatory process. When the SEC proposed the rule, they said, okay, under the Jobs Act, directors and officers and partners of crowdfunding portals can't have equity positions in the issuers whose deals they're doing. And the SEC said, neither can the portal itself. Can't do it. So there was a firestorm of protest about that, because that's one of the main ways, deal people get compensated. They get a warrant or they get some stock for putting the deal together. And so the SEC backed off of that, and so the fourth bullet, I'm pleased to report to you, became part of the regulation. So the crowdfunding portal, even though it's not a broker-dealer, can take an equity position in the issuer. So if you want to use a crowdfunding portal to do your startup deal, you can give a warrant, and you can pay the crowdfunding portal with a warrant if that's the way they put the deal together. Again, it remains to be seen. Are crowdfunding portals going to want to do that? Are they going to want to get cold hard cash? It depends, but they can take equity if they want, and that's long been an underpinning of compensation to retail investment bankers and deal brokers, and these private placement memorandum purveyors and other people who make their living helping early stage companies find capital. And now crowdfunding portals can do it as well. So advertising, as we said, the crowdfunding portals themselves can advertise within certain limits, and the issuers can advertise their offerings and direct investors to the platform, as long as they only keep it limited to a statement that you're doing an offering, where to get to the platform, some of the terms of the offering. You obviously can't promise economic results or anything like that, and factual information about the business of the issuer. And the very last bullet there, the brief description of the issuer's business, that's probably where an issuer is going to have the most latitude to say, here's what we're doing, here's our mission, here's why you should be excited about the opportunity to invest in us. And if there's going to be any sort of puffing or advertising or promoting, that's the category where there's a little bit of little daylight there, a little running room if you want to pump up the offering a little bit. Of course, you're not pumping up the offering; you're giving a brief description of your business. So
Jerry,
now,
before you go
yeah,
go forward, we have a question from the audience. Zachary,
go.
You're on the air.
Oh, hey, on the previous slide, I was wondering the final bullet point. Can
Yeah,
you go back one slide?
yep,
About yeah, and then what is so portals may take equity positions in issuers,
yep.
but then in the parentheses, is that saying their directors, officers, and partners may not, or they may
May
prevent
not,
their directors, officers,
may
and
not,
partners from doing it?
may not.
Okay.
All right, great, thanks.
Okay. So yes, that's regulation crowdfunding for you in a nutshell. I think it's going to be an important piece of early stage funding. I think we're going to figure this out. The SEC has made it a little bit difficult to use. They could have made it harder, even if you can believe that. So they didn't cripple it with regulations as much as they could have. Most of the stuff that they put in there was required by the Jobs Act. One thing I was a little bit annoyed about was, if you want to raise over $500,000 in a regulation CF deal, you have to have audited financial statements. So I predict we're not going to see a whole lot of action in the $500,000 plus deals here, unless we get some good accounting firms that can roll out a really affordable product that fits the definition of what an audit is for companies that have never done anything. So that's a needless hindrance in my view, particularly for early stage companies who have just started out and have had very little operations. The idea that you need an audited balance sheet and audited financial statements strikes me as really something that was thrown in there. And in fact, going back to 2012, this requirement was indeed thrown in at the last minute in the legislative process. So the SEC could have had the flexibility to remove that requirement or to increase the threshold, and they chose not to. So I was disappointed by that. But they could have made it worse, like I said. And as this rolls out, I think we're going to see that portals that have broker-dealers attached to them will have a couple of operational advantages over exempt funding portals that are not registered as broker-dealers. They can be a little bit more selective. They can pay deal-based compensation to their brokers. And really the exempt portals, as we discussed earlier, they're under the regulation, they're kind of seen as more of a passive marketplace. If somebody wants to come and list their offering on your portal, yes, you're supposed to look at what they're doing and subject them to some objective criteria, but you're not supposed to say no. I'm not gonna promote that stock, but I'm going to promote another stock, acting more like a broker. You're supposed to be more of a passive marketplace, but a gatekeeper at the same time. And that's a tension that we're going to see wrestled with, I predict, as this gets rolled out. How much of a passive marketplace are they supposed to be, where anybody can come and stand in the market and say, I have securities for sale? And how much of a gatekeeper are they going to be? And how are those two going to push against each other? So I want to touch base on intrastate crowdfunding. And Linda, I don't think we have a whole lot of time left. But how are we doing?
Well, let me just ask the audience then. We do have about, I don't know, another 12 to 15 slides left. Do you guys want to give Jerry permission to go on till 1:15? Please put your hands up if that's okay with you.
Oh, I don't need that much time.
Oh, how much time would you like?
Yeah. Well, I'm a lawyer. I can compress everything I have to say into the amount of time I have. So,
You're going.
I'll put.
All right.
Yeah.
All right.
I can go another 5 minutes or so, and then we can have questions. How's that?
Okay. Just yes. Don't go much faster than you're going already. I think you're pretty much at warp speed already. So
Okay.
take the 10 minutes, and we'll take questions. Kathleen
Okay.
wants to talk.
Sounds good.
Catherine, I mean. So keep going.
Sounds good. So meanwhile, since 2012, while everybody was waiting for the SEC to issue these rules on Title III crowdfunding, and while people were getting used to Title II crowdfunding and this whole new world was opening up, something else was happening at the state level. Massachusetts in January 2015 became, I think, the 13th or 14th state to adopt what are called intrastate crowdfunding exemptions. Now, since January 2015, I think 10 or so more states have adopted these rules. And I think that these are going to be, for the right kinds of companies, these are going to be as important as Regulation CF Title III crowdfunding. So what is it? First of all, there has always been an exemption, and under the Securities Act, remember, you have to either go file a prospectus or you have to find an exemption. And in addition to the Reg D exemption that 99% of the deals use, as we found out earlier, there's something called this 3A11 exemption. And that says if you only sell to people within a single state, and if the seller, the corporation, is incorporated under the laws of that state and doing business in that state, then that's not subject to the purview of the SEC. The general principle underlying almost all federal legislation is that it has something to do with interstate commerce. And so that's why you see all these references to interstate commerce this and crossing state lines to do that, because Congress is, under the traditional view of constitutional separation of powers, Congress is supposed to be concerned with interstate matters. And so this idea of a truly intrastate set of activities has been declared by the SEC and by the Securities Act to be outside the purview of the Act and outside the authority of the SEC. So the SEC also has a rule that provides a safe harbor under this exemption. And if you stay under the requirements of that safe harbor, the SEC will not require you to register your securities federally. So why do we have interest rate crowdfunding? Why do we need it and why do we have it? I think since 2012, people were waiting for crowdfunding to come around, waiting for crowdfunding to go into effect, waiting to be able to use it, and it was just never happening. The 270 days came and went. 2013 came and went. 2014 came and went. Meanwhile, equity crowdfunding of this type was successfully implemented in other countries, and we saw places like the UK really rolling out crowdfunding and becoming established without any real instances of fraud or any of the regulatory trouble that the SEC purported to be afraid of. So into that vacuum stepped state legislatures and state administrative agencies. Here in Massachusetts, it was the Massachusetts Secretary of State. And they made a state rule that goes along with Rule 147. So this is very limiting. This is only good for some types of businesses in some particular postures of capital appetite. And so what do you need? You have to be incorporated in, let's take Massachusetts, for example. You have to be an entity incorporated in Massachusetts. A lot of people on this call, I bet, have Delaware corporations or Delaware LLCs that are registered in Massachusetts as foreign entities. Nope, doesn't work. You have to be incorporated under the laws of the state in which you intend to effect the offering. So that's major because we're all in Massachusetts right now, and like I said, I bet a lot of people have Delaware companies. So you can't use an intrastate crowdfunding exemption if that's the case for you. 80% of your assets have to be located in the state. So who's this going to be good for? This would be great for like a solar project. Okay? It would be great for a real estate company, like a real estate development project, because 100% of the assets are going to be located right on that lot in this town, in this state. 80% of the net proceeds are going to be used to conduct the business in the state. Again, businesses that sort of stay here and are here are excellent candidates for this crowdfunding. Businesses that are going to make a product and ship it out someplace, I wouldn't even consider this. Too hard to figure out these 80% thresholds. You can only make offers and sales to residents of the state. Okay, so offers. Can you just put the offering on your portal or on your website, or make it by social media? Well, now we're back to this issue of general solicitation. And can you make a general solicitation? It's a different question, but it sort of goes to the same place. What does putting an advertisement or a notice for your intrastate crowdfunding deal on your server in Massachusetts constitute? Does that constitute an offer to somebody in New Hampshire or somebody in Guam? Or can you successfully limit access to that so that you stay on the right side of offering only to residents of the state? For a long time, the answer was, no, you can't do that. Because you put something on the internet, you're making an offer to the whole world. Recently, the SEC has made some interpretations that make it seem more favorable to issuers trying to use their social media or their own websites or a portal to do an intrastate crowdfunding deal. I'm confident that if one were to write to the SEC for a no action letter, which is the way you get the SEC's Corporation Finance Division to say what you're doing is okay, explain the situation to them and explain how you're going to limit access on your website and promise that you're only going to sell to people from Massachusetts, I would bet that they're going to give you a no action letter that says you can do that. That remains a little bit unresolved though, and as of yesterday, my last conversation with the Massachusetts Secretary of State's office, nobody in Massachusetts has done an offering under this intrastate exemption yet. So it remains to be seen how tightly the SEC is going to interpret this this idea of being able to put the information on your website and being able to take the position at the same time that you're only offering securities to residents of Massachusetts. We're going to have to see. So yeah, the rules came out in January. The final rules were promulgated in April, I think it was. We haven't seen any crowdfunding deals yet. The Secretary of State's Office Securities Division purports to be enthusiastic about seeing these deals happen. They want people that want to do a deal like this to let them know and work with them on getting it off the ground. So let's look at this and see if this is something that might be of interest to one of you. The requirements are, first of all, you have to satisfy the federal requirements, obviously, because you've got to be exempt under the federal piece before we can bother with Massachusetts. You can only sell to mass residents. You can sell debt securities. You can sell equity securities. You can, for all intents and purposes, think of it as a $1 million limitation in 12 months. There are some other ways to go, but for simplicity's sake, think of it as a $1 million a year limitation. There are monetary limitations for each investor. Interestingly, though, what you don't have to do, that you have to do under CF, is you don't have to have audited financial statements to raise more than $500,000, and you don't have to use a registered crowdfunding portal. You can put the deal up on your own website. And there's some transfer restrictions. You can't transfer out of state for 9 months. I laugh at that. I don't want, if my clients are doing even crowdfunding deals, even if you're doing a regulation CF deal, I would like to see way more strict prohibitions on the transfer of the stock. It's going to be hard enough to manage the stockholders that are buying into your deal. I'd like to see rights of first refusal for the company to buy the stock back if somebody wants to change it. I'd like to see much longer lockups on transfers until something else happens, until the company decides that it's time to have a secondary market in the stock. I don't want my crowdfunding investors going out and making their own market in the stock and causing me headaches that way, or even distributing the stock so much that now I have to worry about registering under the 34 Act. So if you think the takeaway there, I just unloaded a lot of like securities law jargon at you, but the takeaway is that if you're thinking about a crowdfunding deal, either under the interest rate rules or regulation CF, think about talking to your counsel and to your deal intermediaries about imposing strict holding periods and restrictions on transfer for the shares, because you don't want a market popping up while you're not paying attention and having that whole set of issues to deal with as well, I think. So here's what you can invest if you're an investor. Similar to the regulation CF, you can invest either $2,000 or 5% of your annual income or net worth. That's for sort of regular people. Their income and net worth are less than $100,000. If you have annual income or net worth of greater than $100,000, then you can invest $100,000 or 10% of your income or net worth, whichever is greater. So you can see that under this rule, you can actually get more potentially per investor under an intrastate deal. So if you were doing, I've actually got a client who's doing a real estate type of deal right now, and he's very, very interested in switching out. He's got one investor, and he's like we said before, one investor with more money is usually better, but this one investor happens to be a, I don't want to say pain in the neck, but suffice to say that this client is very interested in replacing that source of capital with a Massachusetts crowdfunding deal, and he's got a project that's going to be in Massachusetts and stay in Massachusetts, and if he can go out and get 3 or 4 people with significant 5-figure investments under this rule, he's going to be looking pretty good. So and there's let's I'd be happy that if this slide was going to be meaningful to somebody, but you have to pretty far down the road for this to be meaningful. You got to hold the funds in escrow, and you have to have a minimum offering. Oh, by the way, let me just talk about a minimum offering for a second. Even if you're doing a Title II crowdfunding deal, I highly recommend. And when I'm representing investors, looking at offerings and looking at deals, I always look for this. What's the minimum offering amount? For example, if I say, hey, invest in my convertible note offering, it's a $10 million offering, and I'm going to use that $10 million to do all these grandiose things and hire a bunch of people and go global with my service, and you're gonna be very happy with me. And then you have to read the fine print. Okay, that's the maximum offering. What's the minimum offering? Is there a minimum offering? What if I invest $50,000 in this $10 million deal, and then I call up 6 months from now and say, hey, what are you doing with that $10 million? How's my investment doing? And I hear, well, thank you for your investment. That's great. We use it to pay our salaries for the last 6 months. Unfortunately, we haven't gotten any other investment, so we're going to close up shop now. That would not make me happy, obviously. And so the concept of what's the minimum offering upon which we can close is a very, very critical one, particularly when you're throwing the offering out there to the crowd and seeing who bites on it. So under Massachusetts, you have to have a minimum offering amount of at least 30% of the maximum offering. That's generous. I would have expected to say, 50%. But anyway, it has to be 30%, and you have to give the funds back if the minimum isn't reached. And then there's all kinds of stuff about if you've ever been in trouble from a securities perspective, you can't use it, which makes a lot of sense to me. And then there's a sort of a mini prospectus you have to write in Massachusetts. I foresee this as a 15 to 20 page document. Your use of the proceeds, whether you have anything, in litigation, who your owners are, who your principals are, risk factors, not an uncommon set of disclosure requirements. Doesn't look overly burdensome to me. And then I put these risk factors in the presentation because these are specifically required under the state regulations. They're pretty silly. I mean, these are the type of things that when you see them in a prospectus or an offering document, you kind of just glaze over it because they all say the same thing. They say it's risky. You can't sell the securities. No federal commission or state securities commission has said they're good, et cetera, et cetera. That's fine. And so what are the advantages of Massachusetts interest rate crowdfunding as opposed to the feds? The federal exemption requires audited financials for over $500,000, which could not possibly be a more empty exercise in filling out forms and completing paperwork. If you have a startup, there's really nothing to audit, and yet you have to go have an audit. And just as important, if not more important, you got to go through this registered portal or broker-dealer under the federal crowdfunding rules. And Massachusetts, so far, is not requiring that, and the final rules don't require it either. So there's some pretty good advantages. And of course, the disadvantages are you have to stay in Massachusetts, and your business has to be sort of stuck here. So who's it good for? It's good for Massachusetts corporations. Maybe you can do it as a Massachusetts corporation and then convert later. I don't know if people will do that. It's good for companies that have to raise funds only once. If you're starting a restaurant, if you're starting a service business, if you need one big asset to start your business, but you don't think you're going to have to raise funds after that, if you're doing a renewable energy project, it's ideal for that. If you're doing a real estate development, if you're flipping a property, or if you want to develop a real estate project. Say you want to develop a real estate project in an up-and-coming neighborhood in Boston, and there's neighborhood resistance to the idea of outside developers coming in. Why not take a slice of equity and offer it to the community under a crowdfunding offering, and to help people share the value that they put into their community. So all these I think are very exciting. And of all the crowdfunding opportunities we talked about, I actually think, and I never thought I would say this, I actually think that the Massachusetts rule is potentially the most useful for people locally. So I'm pretty excited to see it start getting used, and it hasn't been used yet. But I think I don't see any crushing critical prohibitions to its use, like the audited financial statements requirement under Regulation CF. So I think we're going to start seeing it, and I hope we're going to start seeing it. And you can sell convertible debt, you can sell straight debt. In a real estate deal, that might be the most attractive. Or you can sell common stock or preferred stock. You're not limited to what kind of deals you can do. I don't really recommend Massachusetts intrastate crowdfunding for your typical software startup or app developer. It's just going to be impossible to track where the assets are and where the money goes. And also more broadly, and this also applies to Title III crowdfunding as well, what's this going to do to your cap table? How is this going to set your company up for your later VC rounds? Are you going to be able to do a true Series A with a VC for $10 million if you've done a $600,000 deal under CF or under the Massachusetts crowdfunding exemption? Hard to say. So I don't know if we're going to have redemption features in these deals where the VCs are going to come in and say, okay, we're going to redeem the crowdfunding piece at a predetermined valuation, and then we're going to put in the rest of the $5 million Series A round, or whether they're going to tolerate the presence of all these loose, unaccredited investors on the cap table. Typically, VCs like to see a pretty clean cap table, so that's an unknown to me. I don't know whether somebody choosing to do a crowdfunding deal is sort of limiting themselves going forward to what kind of VC investment they can get later on, or whether they're going to have some sort of escape hatch by being able to redeem or buy out the crowdfunding investors at some predetermined multiple in order to clean up the cap table going forward. And having non-accredited investors might restrict your exit. If a public company wanted to buy you with stock in a private deal, that they're in the same position. They have to find an exemption from their deal, and usually they can do it under Reg D. I'm sorry, if everybody in the target is an accredited investor. But if you've got people who are not an accredited investor, then they're not gonna be able to. And if you have 500 investors, each of whom put $1,000 into your company, you might find your phone ringing more often than you want it to. So you're going to have to come up with some way of managing that aspect of life, which goes back to the very first point we made. This has to be something that you can envision yourself doing. You have to envision yourself as being the kind of CEO who has 500 stockholders, or who has 25 stockholders of varying degrees of sophistication and attentiveness, and and demand varying degrees of attention from time to time. And if that sounds like something you can address, and you've got the skill set in your portfolio of tools to do, then great. If that sounds like your biggest nightmare, then you're going to want to think hard about using crowdfunding. So in conclusion, finally, I think both the federal and state programs are important. I think for the right company with the right team in the right circumstance, there are definitely tools that you should be looking at. And but there are complications, there are restrictions. Life's going to look different after you do a crowdfunding deal, and so you want to weigh all that stuff and make a decision as to whether it's worth it for your company. But I'm a big fan, and I think I'm still maybe in the minority, but I predict my brethren at the bar, at the securities bar, are gonna continue to warm to this, particularly as the portals get up and running, as people access the state exemption, and we start to see some successful deals. So thanks for your attention, and I'd be happy to answer any questions or follow up later.
Fantastic. Wow, lots of great information. People are actually mostly still with us, even though we've run a little bit late. I want to make sure that John, who sent in some questions before the webinar, just to make sure that you got your questions answered. But in the meantime, Catherine has been waiting patiently with questions about the real estate side of things, so I'm going to unmute her. And okay. Anybody else has questions, please raise your hand. Catherine, welcome. Catherine? Okay, while we wait to see if Catherine's mic will start behaving itself, see the most recent question is, in transitional neighborhoods, the sellers and investors might not be classified as qualified investors. So is that an issue?
Nope. That's the beautiful thing about the state intrastate exemption. You do not have to sell to accredited investors at all. You got to give them the information, and you're going to want to make sure someone's not spending their life savings investing in your project. That would be too risky. But no, you can take $100 investments from people if you wanted to.
Well, fantastic. So let me take control back here and let everyone know who's still online that the first 6 people to reach out to Jerry get that free half hour of consult with him. So please take advantage. I'll leave this contact information up for a couple of minutes. If you didn't see, I did upload a PDF of the slides into the handout section of the toolbar. So please, by all means, go in there and download them. Catherine,
And by the way,
sorry.
Linda,
Yeah.
That's absolutely correct. Free half-hour consult for the first 6 attendees. I'm glad you didn't continue and say that second prize is a 1-hour consult. But you don't have to. Anybody on the webinar here can just shoot me an email anytime if a question occurs to them, or if they want to talk about it some more. I'm always happy to discuss this further.
Fantastic. I want to discuss it more with you. I have some interesting ideas you have sparked, but that's a separate conversation. Catherine, your hand is up. You are still unmuted, so if you have something else you want to ask, please go ahead. Can sort of hear something. All right, I'm sorry, I don't know whether your mic isn't working properly or what. If you want to type anything in, I am going to go ahead to the next slide and keep an eye on the question box, or please try speaking again. So there is a whole playlist of all of the Ask a Pro webinars we've done to date on YouTube. And I am going to be taking the first 2 off, which was my first one, 4 Steps to a Pitchable Business Plan, and Graham Brooks from 406 Ventures did a nice one on how to get funded from a VC's perspective. And the next 3 that are about getting in touch with customers, what you should not or should patent, and from one of the sponsors of MIT Enterprise Forum, Hamilton Brooks Smith Reynolds, and winning with SBIRs. So all kinds of good things coming up still. Apparently we don't know what's going on with the microphone, so I think we're done with our questions there. A final thanks to the MIT Enterprise Forum of Cambridge, and of course to my friend and colleague Jerry O'Connor. Thank you so very much for spending all this time with us and doing a great job of educating everybody.
My pleasure.
All right. Oh, and I guess actually my last bit of advertising, you can also sign up to get notifications as these new webinars get scheduled for next year at Ask a Pro sign up. It's a bit.ly link. Next week, don't forget, digital design for startups from a really interesting new organization, new design firm called Agenda 28. And most of all, as always, best of luck and success with your startups and everything else that you do. Thank you, Jerry. Thank you, everybody in the audience, and I look forward to seeing you all next week. Bye-bye, everybody.